Supplementary cause list, pronouncement of judgment.
For what has been discussed above, there is no merit in this writ petition, and the same is accordingly dismissed.
Hello.
It was tough. See, you argued in one line, and your writ petition is founded on another line. Yes.
Any mention?
Not I beg to make mention of item 11, man. Maybe listed after vacations. 11.
No objection.
Okay, item 11. The request of the learned counsel for the petitioner and this matter after vacation. Yes.
Obligation. But another item, because there I am for the state, my lord. My lord, here we are to file affidavit, my lord. Affidavit was ready, but some changes are there, my lord. So if it is kindly listed after vacations, we'll file it.
Which item?
This is item 14, my lord. 1-4, Akhtar Ali.
Who is the counsel?
She's for the petition.
You have filed your affidavit? No, not yet.
No, my lord. The permission was granted by this honorable court. Thereafter, my lord, affidavit is prepared. But my lord, it was sent for.
So it is yet to be filed.
Yes,
yet to be filed. Okay, Mr. So-and-so, learned counsel for the appealing of the state respondents 6 and for further time for filing a counter affidavit in the matter. It has not been opposed by the learned counsel or the petitioner. Accordingly, list this matter after vacation. In the meanwhile, the respondent may file their counter affidavit.
Your Lordship, I'd like to mention item number 15 and 16.
Item 15 and 16.
I am for the petitioner, Your Lordship. Also, in this case, the matter is still under consideration pertaining to the exclusion of civil areas, Your Lordship.
Okay.
So we jointly pray that if we may
15,
defer
16.
for 6 weeks.
On the joint prayer, list this matter after vacation.
Oblige, Your Lordship.
Please, Your Lordship, I beg to mention item number 7. This matter will come up after vacation.
Yes.
Item 7.
You are appealing for the?
I'm appealing for the petitioner.
Lordship, similar player in item number 6.
These are all connected matter.
6 and 7.
Your Lordship.
Your Lordship.
This will be joint request.
Your Lordship.
Joint request.
Joint request
6 and 7. Just name the
7, Your
six. And then on the joint request, list this matter after vacation.
Please, Your Lordship, I beg to mention item number 9.
Yes.
Lordship, I pray that this matter come up after vacations.
Yeah, for the petitioner.
Yes, Lordship.
And for the respondent.
No objection.
No objection.
Number 9, the request made on behalf of the petitioner. This is matter after vacation, after the winter vacation.
How do you pledge, Lordship?
May I please, Your Lordship, I beg to mention item number 3, Lordship.
Item 3.
Yes, Lordship. Conducting counsel is out of station, Lordship.
For the state, Your Lordship, in this case.
Let this matter must be
Therefore, adjournment has been made on behalf of the petitioner on the ground that the consent of conducting counsel is out of station. What is it? Prayer has been made to adjourn the matter. Yes. No. Counsel for the respondent, state respondent has, counsel for the respondents have no objection. This matter after vacation. Prayer allowed. This is matter after vacation. Yes. Yes, yes. Court is waiting for you. Tell.
Lordship, item number 2, Your Lordship.
Item number 2.
Lordship, in this matter, we are supposed to file a substitution, Your Lordship, with regards to petitioner number 1. But however, Your Lordship,
Okay.
instruction is still awaited, Your Lordship.
So the limitation period is over. There is a time prescribed, isn't it, for filing substitution application, isn't it? Or not?
Yes, Your Lordship.
Yes. Any objection?
No, Your Lordship.
On the request of the learned counsel, the petitioner releases this matter after vacation. Item 2. Yes.
Lordship, I beg to mention item number 4 and 5, Lordship.
Who's the other side?
I'm there, Your Lordship.
Not opposing prayer.
No, Your Lordship.
4, 5 also on the request of the.
The number 8 has to go, Your Lordship, because these are linked.
Along 8 also connected.
Who is applying for 8? He will do it, even if you don't do it.
Obviously.
He's a specialist in that aspect. Isn't it? 8 also after vacation, isn't it?
Connected.
Or you are objecting?
Most obviously.
Okay. 4, 5, 8, all on the request of the learned counsel for the petitioner, list after vacation.
Then
Similar prayer for item 13, Your Lordship.
Item 13. That bank matter.
Yes, Your Lordship.
Yes. 13 also on the request of the petitioner.
Any question?
Sorry. Your Lordship, I beg to mention item number 1.
Item number 1. Yes.
Your Lordship, let the matter come up after the vacation.
You are for the petitioner.
Yes, Your Lordship.
I am for the statement.
This is state, you are the private respondent, district council.
My district council.
These are NOFMA matters.
No, that is asking for that. That's case will be withdrawn because they are asking for compensation.
Okay. Land acquisition.
for-
Land acquisition.
Yes, land acquisition is not taken place. The construction of the road, so they are asking.
Okay. So we can adjourn it.
Yes.
Okay. On the request of the learned counsel of the petitioner, list this after vacation. Yes, item 1. Like, yeah, see, these are 2016 matters. See,
Yes,
like, if this, see, pendency doesn't give you anything, why should you keep it pending? You should go for disposal. See, unnecessary should not keep this pending.
Please, Lordship. So I beg to make mention for item 12, Lordship. Item 12.
Still remaining, something remaining. Yes.
in fact, nothing is there in the case, Your Lordship.
They are happy to keep matters pending. Yes. Tell, what is to be done? Tomorrow?
No, Lordship, after vacation, Lordship.
The fever is there, Your Lordship. That vacation fever is there.
Okay. Any objection?
No.
Okay. This also on the request of the petitioner, learning us. Petition raised this matter of vacation.
All right.
Fully obliged.
May I please, Your Lordship?
Yes.
Lordship, I beg to mention item number 10. I'm for the petitioner.
Yes.
Did I come out after vacation, Your Lordship?
Mr. Nonklaus matter.
Yes.
That
No objection, Lordship. Lordship, this is a matter with regards to recovery of overpayment.
this also 10 on the request of the learning committee. This left after vacation.
Any pleasure.
Yes.
Much.
Supplementary cost list. Item number 2.
May I please, Your Lordship?
Yes.
Lordship, this is an application under 482 whereby the petitioner seeks to quash the FIR file against him. Lordship, the brief fact of the case is that, Your Lordship, the petitioner is a businessman dealing in a frozen food items, Your Lordship. And during the course of his business transaction with the respondent number 3, Your Lordship, there was some dispute with regard to non-supply of goods. So, the respondent number 3, Your Lordship, he issued a legal notice initially, Your Lordship, which is at page 22, Your Lordship. The first legal notice, if I may just take, Your Lordship, to page 22, Your Lordship. Your Lordship, para 4, the entire payment is reflected, Your Lordship, and the amount that the respondent number 3, they were claiming 15 lakh of due amount, Your Lordship. That is at para 5 of the, that my client again instructed me to inform you that you have stopped supplying the goods after so and so in spite of several orders made by my client against the balance amount of 15,81,061 rupees, Your Lordship. Against this legal notice, Your Lordship, the petitioner replied, which is at Annexure 3, page 22, Your Lordship, whereby we disputed the amount.
You are Mohammed Salman?
Yes, Your Lordship. We disputed the amount, saying that we owe the respondent number 3 only an amount of 5,55,570, Your Lordship. That was the disputed amount, and which we agreed to repay the respondent number 3 as well, Your Lordship. Then again, Your Lordship, the respondent number 3 issued a legal notice, that is Annexure 4, Your Lordship, page 24. Through this, Your Lordship, the respondent number 3 themselves, through his counsel, Your Lordship, in para 2 of the legal notice, submitted that in reply to para 3 of your notice, it is correct to say that an amount of rupees 10,25,550 was not transferred from my client, but due to inadvertently the said amount was wrongly mentioned in my notice, which was sent to your client in the month of June 22. They themselves, they are admitting to the fact that, Your Lordship, this amount was wrongly. So, Your Lordship, during all this business transaction, we completely agreed that we owed 5,55,000 some odd amount, Your Lordship, and we agreed to repay them as well. Then, Your Lordship, during the course of the time, Your Lordship, right after issuing of this legal notice, Your Lordship, on 3rd of February 2023, Your Lordship, the respondent number 3 filed an FIR against the petitioner on 4th of February, which is at page 43, Your Lordship. Annexure 11, Your Lordship.
Yes.
Yeah. So, Your Lordship, right after issuing of that last legal notice that was issued on 3rd of February 2023, immediately after issuance of that legal notice, Your Lordship, the respondent number 3 has filed this FIR in order to pressurize the petitioner to pay that amount, Your Lordship, which was exaggerated by the respondent number 3, Your Lordship. After the FIR was filed on 4th of February 2023, Your Lordship,
yes,
the 41A notice was issued to the petitioner, Your Lordship. Although I fairly submit, Your Lordship, we have not complied, but due to some exigencies, Your Lordship, and the petitioner is constantly in touch with the IO. Very soon, within this week, the petitioner will come and appear before the IO as well, Your Lordship. But the entire dispute, if Your Lordship would go through, is just a civil dispute, Your Lordship. And the respondent number 3 had other alternative as well, Your Lordship, to approach the commercial court as well, Your Lordship. So the entire civil dispute was colored in such a way to make it a criminal complaint, Your Lordship.
Yes.
I'll accept notice on behalf of respondent number 1 and 2.
We will allow the petition now. What is the question of accepting?
My lord, I'll have to obtain instruction from my IO if he has recovered.
I submit that, Your Lordship, that he is constantly.
There's a private respondent is there?
Yes.
Yes, we have. Hard, mister. Well, your name is not reflected in Wakalatnama. Your name is not reflected in the Wakalatnama.
It's not there.
Huh?
In the new Wakalatnama, it's not there, Your Lordship.
It is not there in this Wakalatnama?
Yes, Your Lordship.
But then it should have been written by hand. You have written the name of the petitioner here.
Yes, Your Lordship. Due to oversight, Your Lordship, might be.
It should be written. Your name should be there.
Yes, Your Lordship.
How the court determines, how the registry determines the name of the thing?
In the cause title of the petition, I have given my name filed by.
You are Mr. Joshi, isn't it?
Yes, Your Lordship.
It's nowhere there in the thing. Anyway, you just.
Yes, Your Lordship. I'll do that.
Hard, Mr. Joshi, what Joshi, right?
A. Joshi.
Yes, Mr. A. Joshi. Learned counsel for the petitioner. Issue notice. Returnable in 3 weeks. Mr. S. Changapta. Learned additional PP, isn't it?
Yes, my lord.
Appears on behalf of the respondent number 1 and 2. As such, no formal notice is called for in respect of these 8 respondents. Stop. However, the petitioner shall take steps for service of notice upon the respondent number 3 within 2 days.
Yes, Lord. Lordship, small prayer. If in the meantime IO may be directed not to take any coercive action if he appears before the...
See, the FIR speaks of one thing.
Yes, Your Lordship.
That there was interference in the matter by one association.
Yes, Your Lordship.
And wherein you have undertaken to pay the amount.
Yes, Your
So
Lordship.
if you do it and if you do not pay it,
yes, Your Lordship.
Prima facie there is something. Just wait, let us
Yes,
wait
Your
for
Lordship.
this.
Yes.
This is list according to that.
Oblige, Your Lordship.
You obtain instruction?
Yes, my lord.
Hearing item number 4.
Yes.
My lords had directed the records to be produced before your lordships.
Yes.
Lordship, finally after much persuasion we were able to track the original record.
This is the court has forgotten the entire thing.
The Lordship will recollect the jail matter.
Jailbreak, my lords.
Jailbreak matter, the only issue
I think
raised
the
was
court will require
round
this
of
thing.
litigation before your lordships, my lords. Repeatedly, the
hearing was
punishment
concluded.
was set aside, matter remanded back, and again the same thing happens.
That is the record of the inquiry officer. isn't it?
Lordship will
What about
recollect.
the other parts?
Lordship, this was missing. Lordship, we are giving you
No,
the
this
record.
was a machine, but then where is the other part? Other record?
Lordship, the only plea that the argument was forwarded was they never received the copy of the report. Court wanted to see the record. But that has been taken care of, so then they said they never received the report.
No, my lords, I don't think that was the plea.
Just keep it together. Just take this also. Just you have to refresh the mind of the court, you see, like. It was hard quite some time back, I think.
Well, it was
reserved for judgment.
It was reserved by your lordships on 21/9, and thereafter, my lords, it was released on 10/10.
Yes, on noticing that this part of the record which is
Yes,
it was missing.
So if they want Lordship, they can go through the record.
No, it is already there. I don't
No,
think
if they
this
want to
is-
go through it.
It is already there.
We peruse it, my lords, just for the purposes of
That is,
assisting
if
your
you want
lordships.
to peruse, you see, like you can peruse, but then which part? What for? What is your contention with
No,
regard to that?
my contention would not have any bearing insofar as these records are concerned, my lords. What my learned friend has actually addressed your lordships on this entire matter.
Yes, I think there appears one written submission, gist of her submission. So that is there.
That is
But then, so far as the contention of the state is concerned, that is somehow, you see, like, what was the contention?
Because, my lords, if your lordships, I think I can sum up this entire matter with the observation made by the my lords, appellate authority in his order at page 92. If your lordships kindly have a look at it.
Well,
This would be the sum and substance of the thrust of the petitioner's
what
argument.
page you are referring?
92, my lords. This is the order passed by the appellate authority, my lords.
Yes.
Well, it's the second last paragraph, if your lordship see, it says, while examining the records of inquiry, I have found that the IO has given his findings on the statement of allegations and not specifically on the articles of charge, with the result that his findings are not specific to each article as they could be.
That was answered, Your Lordship will recollect. There was the only issue involved, and there was no denying the allegation of.
In view of the law, settled law, my lords,
your lordships are aware of the law. And so far as this aspect of the matter is concerned, I don't think there's much left in this matter.
So one thing, Mr. Paul,
Well,
just see throughout your contention throughout,
Well,
right from the beginning, the petitioner has never denied his role.
But he has never been given that opportunity to deny.
He repeatedly went on saying that it is not only me solely responsible.
I'm sorry, Mullah.
It is not only me alone who can be held responsible. That is what this all around the thing is. That is the only thing, only defense he took everywhere.
Yes.
Well, I am not on the merits. I'm sorry, Millets, it's fallen from your lordships, but we would have to answer that. But otherwise, Millets, in view of these earlier orders passed by this Honorable Court, once the matter is remanded back, Millets, it was incumbent upon the inquiry officer to return findings with regard to each individual articles of charge, irrespective of what is my defense. Your lordships are aware, Millets, that justice must not only be done, it must be manifestly appear to have been done.
If there remains no difference between statement of allegation and article of charges, then what happens?
Well,
if it is same, even ditto in verbatim also, then what happens?
In this instant case, well, even in that event, I would humbly submit before your lordships, my lords, that the findings would have to be specifically with regard to the articles of charge.
Okay. Okay. Anything else?
Judgment. Whether my lords would like to reserve the judgment today, or lordships would.
You see, I do not know. It would have been better if you had.
We can quickly refresh your lordship's memory, my lords, and we would also then, just rather than making it very long, we can do that. If that. We can have it tomorrow, my lord, subject to your lordship's kind convenience.
See, there are many matters fixed, Mr. Paul.
My lords.
Only thing is that if we fix it and if we cannot take up the matters, then there is no use.
I quite bow down. Or we can have it immediately after vacations, my lords. That would give us some time.
If you agree, both of you agree.
No, sure.
We would not like to burden this court.
Then in such a case, you submit the record on the day. This court will not keep the record today. You keep it with you. And on the day of hearing, will there be a problem for you retaining it?
No.
Just say on the joint request of the parties. This is my authorization. That is better, Mr. Paul, you see. But then this is a 2015 matter.
As I submitted, this is the 5th round we've come back before the High Court.
No, it's a case of dismissal. Why you did not press for it? You say like that, it requires that petitioner should be very much diligent in pursuing this kind of cases. Remaining out of service for about 10 years.
Lordship. No, but he has since retired.
On the basis of an interim order, he is still retaining the court. That was the reason for it.
The interim order passed in here.
Lordship.
No,
I think that was another writ petition. This.
Retired.
He must be paying rent for that thing. No, after retirement, he is bound to pay.
Yes.
That was the consequences. If the writ petition fails, there is a consequences that should follow.
See, whatever the irrespective of the outcome of this, he has to pay for retention.
Rent he'll have to pay, my lord, because the other thing is that his service benefits have also been stopped. He's not getting anything, including retirable benefits. He's not got anything.
Okay.
After
vacation.
Remain is item number 17.
Look, this is a very small matter. The only limited issue is here, my lords, that the petitioner was removed from service by an order. And the limited ground available for us is, my lords, we are saying that that order has been passed ex parte without any opportunity of being heard. The state does not deny that, my lords, that there is no proceeding.
That is a government school or it's a deficit school or...
Before going into the merit of the case, Lordship, in this case, the petitioner is supposed to file a miscase completing the managing committee as a party. That they have not filed it.
Well, this is the query that had fallen from your lordships. It may not be necessary. I have examined the matter. It's not necessary for the purposes of this, because the impugned order is passed by, my lords, the government.
But then that is the order should reflect that you have to file it.
Some prayer was made at some point of time before your lordships on this.
No, it's recently a prayer is made.
Well, it had come before your lordships on the 1st. And I had apprised your lordships, my lord, we'll just examine that. The order for impletement, my lords, your lordships would find it at 12/9/23.
That is further 2 weeks. But then before that, there must be some order.
4/8, my lords.
Now, if it's a case of dismissal, how the shockers notice for absence comes?
Interesting.
No, but then in such a case, managing committee will definitely will not be important.
Well, here the issue is that if your lordships just have a look at the impugned order. Annexure F, page 19, my lords. The lordships will kindly see.
But in this case, the petition has been taking time to implement this managing committee as a party.
Yes, this is order.
And all these days, they have
Okay.
been.
These officers, today's division bench matter also, I think there is a report. We had a matter which.
My lords, I was there, I was present.
It's the same official.
My lords, repeatedly this is something that is coming from Garwals. Not isolated in this matter or any other matter, well, we may be on either side, but these kind of orders are passed. Your lordships will kindly see. Somebody else is appointed and my appointment is...
You are Saidul Rehman.
Treated as cancelled.
That is the only document. Nothing. Now, where is your approval order?
My lords, my approval, your lordships would find it at page 13, my lords. Annexure B, page 13.
It's provisionally approved.
Provisionally approved.
This is in 2016 probably, isn't it?
Is
it?
This is dated the 20th of December 2016. Thereafter, my lords, there is an allegation against me, an inquiry is held. Again, there is an inquiry. My lords, inquiry finds that the allegations made in the complaint are baseless. And thereafter, one fine day, my lords, I am greeted with this order of 10 July 2019.
Now, is this 10 July has a reference of another letter, another memo? Can we have, is it this part of record?
School complaint, Well, it is not part of our records. The state can produce it. This would be some state's letter.
This managing committee is the appointing authority. The state is just the approving authority.
Whatever it is, this is cancellation of approval. Cancellation of approval.
Managing committee is necessary party. For that reason, they have been asking time and again.
Okay, we'll take care of that. But we just see, we'll just see it. Okay, if they do not implead and if we find that the party is necessary party, writ petition will fail on account of that. Okay, if that be the thing, because you see, they are the master of proceeding. If they do not want to impute somebody, or if you say that is not maintainable, then okay, we have to address that issue.
Then your lordship may take a note of that.
No. What is your? Do you contend? Do you like to contend that in absence of managing committee, no effective order can be passed by this court?
That is not our submission, but the submission is that the petition they wanted to implead.
If it is not your thing, then to definitely
they don't want to implead. So let that may be recorded and let.
No, but then see, okay, right now just what about this letter? Letter dated 3/7/2019, in reference of which this impugned order was passed.
School complaint 2018-178.
You filed an affidavit in opposition.
Well, the state has filed an affidavit.
Any explanation about that letter in their affidavit in opposition?
No, my lords.
Anyway, if you want to finish it, we will sit in the after the lunch break. I think it's already time.
Yeah.
Are you ready for hearing?
Sorry, my lords, I did not notice. We are actually on your lordship's
It is not that to look at watch. It is my feelings which tells me what is the time.
You have to do it today.
You will do it today or
tomorrow, day after, whatever. Short matter, my lords.
We will not keep anything. See,
Let
do
it
not
go
want
after
to be
vacation.
burdened with so many
Let
judgments,
it go
Mr. Paul.
After vacation, yes.
Yes, on the joint request of the parties, list this matter after vacation. Kindly see about that letter. This will be. We'll just try to find out what is the reason.
I'll oblige.
There's one more matter.
Sorry. Item 7 is there, Your Lordship. Item 18.
Item number 18.
So we'll have to have it in the second half if you are anxious to do it or otherwise.
We'll have after vacation, Your Lordship. Only my friend has brought there, yeah. Let him keep in a type copy, Your Lordship. This is all.
Written with you. There is no problem. You can give it. Okay. Okay. After vacation, on the request to the parties.
Oblige.
Oblige.
Sorry, the court should not have.
5 more.